Good morning. You're Ryan Hodge.
Yes, ma'am.
And Mr. Kimler, will your client waive the formal reading of the indictment?
So waived.
And we're going on the full indictment, correct?
Correct, Your Honor.
Mr. Hodge, in cause number 24, DCCR 1167, you're charged with third-degree felony offense of evading arrest or detention with the use of a vehicle from April 11th of 2024. Your indictment further alleges that you were previously convicted of burglary, a second-degree felony, May 12th of 2015 in Grady County, Oklahoma, and on that same date also convicted of possession of a controlled substance in Grady County, Oklahoma. And then after those were final, you were convicted March 20th of 2018, also in Grady County, Oklahoma, of bribing an officer, and on that same date convicted of a felon in possession of a firearm in Grady County. How do you plead to that charge? So how do you plead to the original charge that you're evading arrest or detention with the use of a vehicle?
Guilty.
And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And so, is there a fine agreed to?
I marked a fine. I would look that up to the state.
500 is fine.
At first glance, this sounds like an incredible deal. 10 years of deferred probation instead of prison. But don't celebrate just yet. Here's the catch. Because Ryan admits to multiple prior felony convictions, this probation comes with a hidden trapdoor. One serious violation doesn't just risk prison. It could trigger a mandatory minimum sentence of 25 years. That's not a warning, it's the law. Would you take a deal knowing one mistake could cost you the next quarter century?
So it looks like the agreement that you've reached with the district attorney is for a 10-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? I want to make sure you understand that because you've entered a plea of true to all of those prior felony convictions, that this is a little different than a normal 10-year deferred. If you violate, your minimum punishment by law that I could give you if you violate this probation is 25 years. Non-negotiable, because you've pled to it this way. If you violate the...
This is not ordinary deferred probation. By pleading true to multiple prior felonies, the defendant triggers mandatory enhancement law. Probation may last 10 years, but one violation instantly opens a non-negotiable 25-year prison floor. That leverage now belongs entirely to the court.
Minimum is 25. Do you understand?
Yes, ma'am.
Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Mr. Hodge is not competent?
None that I'm aware of, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your case, and then we'll come back later for sentencing. Do you have your discovery certification?
Yeah.
Okay. Go ahead.
Can I inquire if he has a GPS judge? I know he resides in Oklahoma. I don't know if that would be something that...
Was it part of your bond that you have a GPS monitoring device?
Yes, they have.
So are you wearing that
Yeah,
now?
they have.
Okay.
You have it on me right now?
No, they've taken it off since prior. I had a problem with it, but I came down there. I've been checking in twice a week. They changed the stipulation of it, but
So
they said as long as they...
Notice what the judge is doing here. She hasn't officially sentenced him yet. Instead, she's ordering a pre-sentence investigation, or PSI. Think of it as the court's final background check. Between now and sentencing, every decision Ryan makes matters. Miss one appointment, pick up a new charge, or ignore probation's instructions, and this favorable plea agreement could disappear overnight. The ball is completely in his court.
They changed.
It might have been, so your bondsman had that condition on you?
Yes.
Not the court, okay.
Yes, but she said you've been following up and going to court, everything's been good.
Okay. All right, so it's very important, obviously today, stop and talk to probation. She's gonna let you know what you need to do. You're gonna need to go to the probation department before you leave. You're gonna have to set up that appointment for that pre-sentence report. If for some reason you don't do that and you don't follow through, then you run the risk of me not accepting the plea agreement. Obviously, things could be much worse. If you're arrested for anything between now and when you come back for sentencing, obviously, I'm not gonna accept the plea agreement. Things can be a whole lot worse. Do you understand? All right, stop and talk to probation. We'll see you at sentencing. Good morning. Are you Monique Wynn?
Yes.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Wynn, in cause number 24 DCCR 1298, you're charged with the state jail felony offense of theft of property from April 8th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
And so is the agreement, it looks like, for a 12-month term in the state jail prison?
Yes, Your Honor.
Yes,
She
Your Honor.
has 11 months
Okay.
of back time.
Okay,
So she would have to serve one more month.
okay.
The defense is requesting if she could turn herself in on Friday. She has
Now the entire case changes. Up until this point, it sounded like a routine shoplifting plea with only about a month left to serve. Then prosecutors reveal investigators believe she was connected to a retail theft ring responsible for roughly 29 thefts and nearly $50,000 in losses. Whether every allegation is ultimately proven or not, that's enough to make the judge think twice before extending any extra trust. Sometimes it's not today's charge that changes the outcome, it's the bigger picture.
3 children that she needs to get situated.
Well, so what we need to do is, I'll go through with the plea, but not sentence her, because if I sentence her, it just turns into an issue if she doesn't.
Okay.
Motions for new trial and things like that, there's really not a lot of things we can do. So, I can take the plea today. We can do the sentencing Friday. We can do the sentencing Monday during the next docket.
Okay.
I'm willing to do the week, whatever.
Couple of things, Judge. If we can maybe put on the record how we arrived at that time. And also there's the state, well, ordinarily I wouldn't be opposed to a defendant turning herself in at a later date.
Here's what just changed the temperature. What appears to be a single theft case is now framed as part of an organized, multi-county scheme. That context doesn't alter today's plea, but it directly influences how much trust the court is willing to extend before sentencing.
This plea was contemplated prior to today. In other words, this defendant knew that there was a very good chance that she would be going the other day. On its face, it just looks like a plain Jane state jail felony theft. But Judge, it appears that she may have been a part of a theft ring that committed more than 29 total different crimes to the tune of about $50,000, Judge. So with all that being said, I'm not so amenable to her turning herself in later, but of course it's up to the court.
So here's what we'll do. We'll go through with the plea, and then we'll be here and do sentencing this Friday at 9 a.m.
Yes, ma'am.
Can you do that?
I have municipal court Friday morning, but
What time?
we typically start at 8:30. But I could,
I mean, it won't take long.
yeah, I can tell them I'll need to leave and come and go back.
I mean, we can do this at 8:30, and then you can just, instead of starting and stopping, and just be, I mean, it'll
Little
take
late,
10
yeah.
minutes.
Okay.
Would you rather that?
Yeah, that's
Instead of starting and stopping, just let them know you'll be a little bit late?
Yes, that's fine.
Okay, so that's what we'll do then. All right, so, and you guys have talked to the clerk about the credit?
Yes, so there were several counties in which Ms. Wynn was transferred throughout from 2024 to 2025.
For various thefts.
Yes,
Okay.
from various thefts in various counties. So we have, we know that Jefferson County put the hold on her in June of 2024,
Okay,
and then she was released in May of 2025
okay,
after completing all the other counties.
okay,
Yes, ma'am.
gotcha. All right, so is that your understanding of the agreement?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Nguyen is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily.
This is conditional mercy at its most fragile. Until sentencing occurs, the plea agreement is not guaranteed. Any arrest, missed appearance, or failure to comply gives the judge full authority to reject the deal and impose a far harsher outcome.
Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing to this Friday, which is January the 9th. Thank you. At 8:30 a.m. It's very important that you're here on time because Ms. Holmes has something else she needs to do in another court. And so we'll all be here early. We'll get your case taken care of. You'll go into custody. If you don't show up this Friday, well, just let me go. Good, I hope so. But let me just, if you don't, then I don't have to accept this plea agreement and things could be worse. You understand? Also, if you're arrested for anything this week between now and when you come back Friday, you run the risk of me not accepting that agreement. You understand? And it sounds like there's the hold, there's some documentation of the hold that we had. And so the credit from that June date in 2024 to the release date in May will be granted as far as back time.
Yes, ma'am.
Did we already admit one?
No, Judge.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Nguyen is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, again, I'm going to reset your case until Friday at 8:30. We do not need a pre-sentence report. You'll come in and be ready to go that day with the bailiff, okay? All right, we'll see you Friday morning. And you've got your certification. All right, ma'am.
Good morning.
You are Brittany Davis?
Mm-hmm.
Please say yes or no.
Yes.
And Ms. Davis, this is your initial appearance in cause number 25, DCCR 1450. You're charged with the second-degree felony offense of assault on a peace officer from May 19th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
It's been worked out.
What's been worked out?
I had to reveal my details with you as far as how I'm gonna proceed, because I don't know if I think I'm gonna represent myself. Or I'm
Okay.
gonna have my lawyer do it.
Okay, well, that's two very different things.
Yeah, I'm everywhere with it right now.
What
I'm everywhere with it right now.
are you? So if so if I test you today, you can have anything in your system?
Of course.
Have a seat in the jury box. How are you, sir?
What Judge, how you doing?
Happy New Year. All right, sir, you're Miguel Reyna. And Mr. Reyna, this is your initial appearance in cause number 25, DCCR 1687. You're charged with the third-degree felony offense of driving while intoxicated, third or more. That's from September 19th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Have you already hired one?
Yes, ma'am. He said he's on his way.
Who's that?
John West.
Okay, if you'll haven't received anything, when did you get him hired?
As soon as I got him.
Okay, if you'll just have a seat here in the courtroom until he gets here and he'll confirm that, and then we'll get you a new court date, okay? Don't leave until we talk to him or let you go.